We want to begin with you, Reed, if we can. This one comes from Kim, who said that personally she got into a real bad wreck the other day. Her husband was in the vehicle, still in the hospital, but the insurance people have been calling already. What should Kim do? She's pretty upset and she's kind of concerned about saying the wrong thing.
Well, the first thing that she should do is not talk to the insurance company. I know that sounds counterproductive, but she doesn't know the full extent of the damages. And when she says she doesn't want to say the wrong thing, she is going to say the wrong thing, because even honest answers can be misinterpreted. And so you can say, well, I have my neck hurts, or we've had cases where somebody said my shoulder hurts. And later down the road, maybe a couple of months, they find that shoulder pain is actually stemming from your neck. Well, then the insurance company says, well, you didn't even mention your neck. How can your neck be injured? You've been for 3 months talking about your shoulder. So it's better to say nothing at all, especially in an extreme injury. Get an attorney. You got to find out what the limits are, find out if you can get the bills reduced, all that stuff. So the first thing she needs to do is have no contact with the insurance company and talk to a good trial attorney as soon as possible.
When in doubt, do nothing?
Absolutely.
All right. Chase, pretty much the same, whether it be Georgia or South Carolina. That's just a good rule of thumb.
Yeah, under those circumstances, it's always good to talk to an attorney. In most cases, it's free when you have a personal injury claim, and they're going to give you at least some good advice. Most people in these situations are kind of lost in the woods, and the attorney can kind of point you in the right direction. Whether or not you end up using them or not, they can point you in the right direction, especially before you talk to an insurance company, because they only have one thing on their mind, and that's saving themselves money.
And I know, Chase, me and you talk to people all the time that come in that might have a case that that we don't take, but we can certainly give them advice on how to handle it. If the bills are very low, if the injuries are very minor, we can advise you on how to go and do it yourself. And then if we see something in there that needs some kind of expertise, we can jump in and help you.
Yeah, that's one of our policies, is that if we don't make a difference, we don't make a dime. So if we can't make a difference in what you'd ultimately recover in the case, then we advise you not to, use an attorney, especially if you're, willing and able to handle something like that yourself.
And gentlemen, what Reed was speaking of, would that be magistrate's court where there's a certain limit? Is that where you would sort of defend yourself?
Well, did you ask Reed there? I'm sorry, Neil.
Go ahead, Chase. Go ahead.
Okay, yeah, sure. Yeah, there's a claim process prior to where you can actually negotiate with the insurance company, but under no circumstances do we advise you talking to them. Usually, if we advise a client to handle it themselves, we explain to them the basics of, you have to have your medical records, you have to have your medical bills, and you have to submit them along with a letter to the insurance company demanding what is fair in the case. And we advise the clients that if they're going to do that everything should be done in writing. It's a little more clear when you put things in writing, and things can't necessarily be interpreted or changed about what was said and at what time. So if it goes beyond that, then yes, you can go to magistrate court, and a local magistrate will help you resolve that claim.